Well, just before I go into each of the points, Malas, there are, if I may submit, there are broadly two approaches your lordships have followed. Malas, this is at the risk of slight oversimplification in matters of reservation. Malas, one is, if I may articulate it, the cautious approach, where the court is primarily concerned with preventing misuse of reservation, ensuring that it goes to the right people, ensuring that hopefully in a certain amount of time it comes to an end. Whereas the order in reference which the learned Advocate General just read is, in my respectful submission, example of that approach. And Malas, there is another approach, which is the deepening approach, which is, Malas, the court is primarily concerned with how to deepen the impact of reservation to all the groups. And that is the primary concern which the court is really concerned with. Because my respectful submission is that the question of subclassification within scheduled castes and scheduled tribes, irrespective of which of the approaches the court takes, leads to the same conclusion.
That is the first approach you say?
Because I said it's a cautious approach, where the court is more concerned with the formal mechanisms of reservation and preventing its misuse.
Yes.
In the second, my lord, the court's emphasis is more on deepening the impact of reservation. If I may say so, my lord, the Chief Justice's judgment in Pavitra is an example of the deepening approach. And my lord, my submission is that irrespective of which of those two approaches the court takes, both of them lead to the same conclusion. That is, subclassification is not just constitutional, but possibly desirable and necessary. Well, second, it is clear that the principles which apply in the context of reservation versus non-reservation can be mirrored in the context of subclassification within scheduled caste, no doubt about it. Well, the same principles can be mirrored, like my Lord the Chief Justice pointed out in the morning. However, my Lord, in my submission with one difference, and that is that when we are dealing with scheduled caste, we are dealing with the weak and the weaker. There is no forward group. Plus, that distinction is of some essence. Because, Malas, this subclassification, either in the way we formulate our submissions or Malas, the legislature or the court engages, should not be used to beat the parent category of scheduled class itself. Plus, that is also essential. So really, we are discussing not a forward, backward, or more forward and backward within backward. We are discussing weak and weaker, Malas. So with that distinction, Malas, I will just broadly go into my first submission. Malas, this is Justice Hegde speaking for the majority. The conglomeration of castes given in his presidential order, in our opinion, should be considered as representing a class as a whole. The contrary approach of the High Court, in our opinion, was not correct. The very fact that a legal fiction has been created is itself suggestive of the fact that a legislature of a state cannot take any action which would be contrary to or inconsistent therewith. The very idea of placing different castes or tribes or groups or parts thereof in a state as a conglomeration by way of a deeming definition clearly suggests that they are not to be subdivided or subclassified further. If a class within a class of members of the scheduled caste is created, the same would amount to tinkering with the list. Such subclassification would be violative of 14 of the Constitution. It may be true, as has been observed by the High Court, that the caste system has got stuck up in the society, but with a view to do away with the evil effect thereof, a legislation which does not answer the constitutionality cannot be upheld. It is also difficult to agree with the High Court that for the purpose of identifying backwardness, a further inquiry can be made by appointing a commission as to who amongst the members of scheduled caste is more backward. Now, this is important. If benefits of reservation are not percolating to them equitably, measures should be taken to see that they are given such adequate or additional training so as to enable them to compete with the others, but the same would not mean that in the process of rationalizing the reservation to the scheduled caste, the constitutional mandate of 14, 15, and 16 be violated. So, what the court is suggesting, and this becomes more explicit in Justice Sinha's opinion, which I'll just read now, is that you can take other measures for them, but not reservation. That is the suggestion. And that will become explicit. Your lordships will now have para 10114.
What is the remedy?
That's right. There is one practical aspect of the matter which may not also be lost sight of. The chart produced before us clearly shows that the members belonging to Reli and Adi Andhra are hardly educated. What are necessary in the situation was to provide to them scholarship, hostel facilities, special coaching, etc., so that they may be brought on the same platform with the members of the other scheduled tribes, namely Madiga and Mala, if not with the OBCs. It is not in dispute that the members belonging to Reli are hardly educated. only 2% of members of the said community have studied in secondary school. And then there is some discussion, etc. So what the court is suggesting as a remedy is that you give other forms of affirmative action only to the subcategory. That, in my respectful submission, is a contradiction in terms of interpretation of 341 itself. Because 341 is scheduled caste for the purposes of this constitution. It doesn't say for the purposes of reservation alone. So my submission is, in their imagination, the court, the CJI court has assumed that 341 is really for reservation. You can do these other things which will not hit 341. But in fact, those very things which the court suggests will equally be hit by the interpretation of 341.
In fact, they are supporting your argument here.
In a way, yes, Manoj. So what I'm really saying is that if what the court suggests is possible.
And identified them and accordingly dealt with it.
Correct. So Manoj,
I accept the position that there are more backward among the backward.
yes, correct. So factually they concede, the court says that factually the problem exists. And it says
But
the
reservation is not the remedy.
reservation is not the constitutional remedy because it's not permissible on account of my interpretation of 341. But at the same time, the court says there is other remedy. What I'm saying is either both remedies are available to me or none are available to me.
They couldn't have said that you take this and not the other.
That's right. And Manoj,
The
that,
purpose of Article 341 cuts across the Constitution.
that's right.
It's not-
And Manoj, that will become evident when your lordship looks at Article 46. Because for the purposes of this constitution, of course, reservation under 15.4 and 16.4 is one aspect. Now just have a look at 46.4. I know your lordships are aware of it, but just for a moment have a look at it. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. The state shall promote with special care the educational and economic interest of the weaker sections of the people, and in particular of the scheduled caste and scheduled tribes, and shall protect them from social injustice and all forms of exploitation.
This is actually a postulate that the scheduled castes and scheduled tribes are deemed by the Constitution to be weaker sections.
I'm grateful. Absolutely. And Manoj, this 46 is couched in such broad language that any affirmative action will be covered under this for the scheduled caste and scheduled tribe. Scholarships, the kind of examples the court gives in CJI will be squarely covered by 46. And if my lord now has 15.4 for a moment, because those measures are in effect protected by 15.4. A government can give scholarship to only a subcategory or a group only upon protection from 15.4. So 46 and 15.4 are really two sides of the same coin.
All right.
So Manoj, that is my submission, and therefore the logic of CJI, if applied fully, in fact is in my favor. Manoj, I'm grateful to Justice Nath for that. Manoj, my second submission is that there is a new provision introduced in 2018. And Manoj, that is 342A. Your lordships will just have that provision first. It is similar but not identical to 342. And Manoj, something, that's why your lordships were then required to interpret it in one judgment. 342A Part 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof by public notification, specify the socially and educationally backward classes in the central list. Plus, this is actually amended. Specify the bracketed portion your lordships will leave and be deemed to be socially and educationally backward in relation to the state or union territory as the case may be. Because initially there was no reference to central list, but clause 2, Parliament may by law include in or exclude from central list of socially and educationally backward classes specified in a notification issued under clause 1 any socially and educationally backward class, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. So Manoj, clause 342A as it originally stood, part 1 of it was almost identical to part 1 or clause 1 of 342.
Right.
But insofar as clause 2 was there was the word central list, which is different even as it originally stood from 342. Therefore, the question which arose, Manoj, in Jayashree Patil's case is what is the real intent of the original amendment to 2018 amendment? Because the word central list is there. So is it taking away the power of the states to actually
Yes.
Identify the OBCs?
Yes.
Because Manoj, this is a provision which for the first time is introduced in 2018. So the power to identify was all, unlike the SC/STs, the power even to identify was always with the states for OBCs.
Yes.
Now this provision is introduced 342A, and the question was, is that power lost?
The power of the states.
Power of the states to identify.
Yes.
And the court says, yes, it is lost in Jayashree Patil. By reading, the question was whether 2 will control 1, clause 2, central list will control 1, or 1 will control clause 2, really speaking. And the court came to the conclusion that the word central list in 2
Yes.
will be controlled by 1, and therefore the states have lost the power. So although the word central list is there in 342, in Jayashree Patil, your lordship says, in effect, 342 capital A is identical to 342. That is, from here on, for all purposes, not just central list, it will be only the president and thereafter the parliament which will identify the caste. Because that is the majority in Jayashree Patil. Because there's two judges dissenting also, but that's the majority, 3:2.
They also then held that till such time as the central government identifies, the state list will continue. So the central government has not so far identified, so the state list continues.
Oh, I see.
As a matter of fact, but not, that also then needs to be looked at again, because the entire federal structure is disturbed because the states don't have any power anymore.
It came in 2021.
So 21 is the
21.
So that's the whole issue.
But the 21 amendment was before Jayashree Patil, right?
No, after. As a response to Jayashree Patil. No, I'm just coming to that. I'm just coming to that.
18, this is 2018.
Jayashree Patil was which year?
20, Mullah. Jayashree Patil is 2020.
This is 21.
Mullah, the amendment is a response to Jayashree Patil's finding. I'll place that. I'll place that. Yes. Now, my lords will just first have, now the submission I'm making for the court's consideration is this, that even in Jayashree Patil, where the court interpreted 342A to be identical to 342, even though the word central list were present in the second part, despite that says that for all other purposes, that is subclassification, etc., nothing changes. So here you have now for the SEBCs, a structure like 342, but they are permitted to, the states are permitted to subclassify. Plus, that's my submission. I'll just make that good by taking your lordship through the judgment. So now on Jayashree Patil, your lordships will straight away have page 1462 is where it begins. 162. Parliament through the 102nd Amendment clearly intended that the existing legal regime for identification of communities as SC and ST and for inclusion in the list of SC and STs under Article 341 and 342, which had hitherto existed, ought to be replicated in relation to the identification of SEBCs. To achieve that, Parliament inserted Article 338B, which is a mirror image of Article 338 and 338A. The task assigned to the new Commission for Backward Class, which is envisioned as a multi-member commission, are radically different from the duties which were assigned by Parliament to the National Commission for Backward Caste Act. Under Section 9 of the erstwhile NCBC Act, which was repealed just before the commencement of the 102nd Amendment, the NCBC was to examine requests for inclusion of any class of citizens as backward classes in the list, and advice of the Commission was ordinarily binding upon the central government. Section 11 provided for a periodic revision of lists. As noticed by Ashok Bhushan J, Article 338B envisions a larger role for the new commission. This commission not only advises the central government but also the states. It is impossible to read Article 338B in isolation from the pre-existing pari-materia provisions. It must be interpreted in the light of the two provisions which had existed all this while, 338